Good afternoon. This is Judge Goldblatt. We are on the record in Ray Allegiance Coal USA Limited, which is case number 22-10234. I'm sorry, 23-10234. Thank you, Ms. Barksdale. I've obviously received the parties' letters and here. I appreciate everyone jumping on relatively short notice. I thought with a hearing, with cash collateral expiring by Friday and the possibility of a hearing for the continued use of cash collateral then, it made sense to get to the bottom of the discovery issues and give everyone a reasonable opportunity to deal with whatever it is we decide. One preliminary note, and my apologies if our chamber's procedures aren't clear on this. I am 100% fine for a dispute like this proceeding by way of letter, which I think is easier. I'm not sure it's how much easier, but a little bit easier than doing a formal pleading process. We will go ahead and docket the letters, but in general, while we're happy to do it by letter, and I appreciate it being sent to chambers by email, I'd also ask in the future that they also be docketed so that these are public proceedings, so that people who are interested in the case will have a chance to know what's going on. With that, I've read the letters, but why don't let me do my best to give everyone a chance briefly to state their positions before I jump in and start peppering you with questions. So, Mr. Denny, I guess you filed the first letter. Let me give you a chance to be heard.
Thank you, Your Honor. Ronald Denny from Morris Nichols on behalf of the debtors. Can you hear me okay?
I can. I should say that in the conference room, the audio isn't great. I don't know if there's a way to be closer to the microphone, but you are audible, but I hear you less clearly than I would if you were at the podium here.
I would much rather be at the podium here.
Fair enough. Okay. That actually is helpful.
Okay.
You don't literally need to hold it in front of your face while you talk, though.
Well, Mr. Harvey did such a good job last week. Maybe I'll let him hold the microphone. So if you can hear me okay, Your Honor, I was not able to attend the hearing live. I mean, I was zoomed in, but I was pretty sick. But I listened to the hearing and heard Your Honor schedule a hearing for this Friday to encourage the parties to speak. We had a meet and confer Friday and discussed the ways forward, and that if we were going to have a further hearing, valuation seemed to be front and center. I won't get into Mr. Harvey's presentation about the burdens of proof and who has to do what. I only need to look at Mr. Lucas's objection, where he just starts off on valuation and a creditor's rights and obligations under 363, looking at paragraphs 12 through 16. So clearly valuation of our assets, as well as what they believe they're collateral, because they're two different buckets potentially, and we wanted to understand, are they different buckets? But certainly we believe they were relevant. So we had that discussion on Friday. We had a further discussion over the weekend where we reiterated we really think we need the valuation. We understood his clients did not really want to produce it, but we understood that, but that's not how it works. And then we asked for their official position by Monday so that we could reach out to chambers so that we were not stuck with the hearing on Friday without any information. And here's where we are. I can get into why we think it's relevant, but I think we're in a contested hearing where it is at the fore and it is discovery. And while I read his letter saying assumptions have changed, that's sort of different. That's different from produce it, we review it, we all can decide evidentiary how it comes in and wait and deal with assumptions and changes.
Okay, so Mr. Denny, I understand all of that, and it makes a measure of sense to me. But while you have the mic, I'm actually particularly interested in your response to the things they want from you.
So here's where we are on that. We received their letter yesterday, Your Honor, asking for information. So the client is now working, we hired Capstone, Your Honor, as our financial advisor and investment banker. So Mr. Gronke and Mr. Walker, remember, it's a pretty thin team, but they are with the Capstone people now. We obtained the letter from Mr. Lucas. We forwarded it on to the clients. They're gathering information. To be clear, we have the ability, if the concern is, are we able to track it and identify, Your Honor, where the piece of coal is, at what point in time, how it turns into a sale. We have that information. We'll gather that information. So that part's easy.
So Mr. Denny, just to be clear where my head is. Look, if you guys are able to work things out, that's terrific. And, I'm much less likely to get something wrong if you hand me an agreed order. If you don't, and for now I have to proceed on the assumption that you don't, my primary concern is giving everyone the opportunity to have a fair hearing. So I'm less concerned for today's purpose about what you'll be able to show in the fullness of time than I am in what can you produce to Mr. Lucas like tomorrow or promptly in order that he has a fair opportunity to test the assertions that you're going to make at the podium. Does that question make any sense?
Well, the problem, it's a chicken and egg, Your Honor. So the information he's asked for, we're gathering information. So financial statements and the like, to the extent it exists, we will gather it and produce it. There is no care and maintenance budget, right? He wants that.
Right, and so to the extent he's asking you to create things that don't exist, you're not going to produce that tomorrow.
Correct. To the extent we have it, we are gathering it, and we are fine producing it. When I say chicken and egg, you suggested you want to make sure Mr. Lucas is not surprised and has an opportunity for the hearing. And I will tell you, we're turning it around in 24 hours. We've been asking for the information he put at issue since Friday, and we're the ones who are prejudiced by a delay.
Okay, well, there's nothing I can do about what happened before we got here now, right? All I can do is do my best to be fair to everyone now that I'm here.
And Your Honor, can I just touch on how some of what is so easy for them to produce? So we know they closed the loan May 24, 2022. We know the second tranche was in August of 2022. We know that in August of 2022, CSA Global was commissioned to do a life of mine evaluation of both properties. And that was done because they wanted an independent third party to do it. Likewise, around the same time, they obtained a valuation from Cushman & Wakefield of all plant, equipment, and the like. We know this because we were asked to pay for it. I asked for this on day one, pretty easy to produce, nothing produced. I'm sure they have other valuation information, but on the one hand, they say they're undersecured, but honestly, Your Honor, when you look at the facts, we think that's not the case. But we're entitled to explore it before I go to a hearing to start talking about, are they adequately protected or is there a cushion?
All right, so let me talk to Mr. Lucas about that, and then I'll also hear from him the priority items that he wants from you, and then I'll come back to you. So, Mr. Lucas, as to the valuation documents, I saw your letter. I understand your argument that it may be there are reasons why whatever it says is not correct as of today, but that's not a particularly powerful 401 argument. And so I'm interested if you've got a better reason than that why you shouldn't be required to turn it over.
It's the debtor's burden to show that Collins Street, Your Honor, Your Honor, John Lucas, patrol
Yes.
for Collins Street. It's the debtor's burden to demonstrate that Collins Street is adequately protected. It isn't Collins Street burden.
No, Mr. Lucas, you're confusing two different questions. One is who's got the burden at trial, and the second is who's required to produce evidence so that the other side, so that each side is able both to meet its burden and to respond to your case. It's that they've got the burden of proof doesn't mean that if you've got the documents that would allow them to meet it, you're allowed to hide them from them. So I don't think the burden of proof point is responsive at all to the question of whether you should be required to produce them.
Your Honor, I don't understand how the documents could be used by them to satisfy their burden of proof. If we turned them over, Your Honor, they would be hearsay.
All right. Well, we can deal again. The fact that it might not ultimately be admissible at trial is also not a reason why documents that are relevant, meaning they tend to demonstrate that a fact that is at issue is more or less likely to be true, shouldn't be produced. So do you have an argument about burden or something, or a better argument about relevance, which I think would be challenging to make? I'm candidly surprised that we're here on this dispute. I'm happy to hear you out, but I haven't yet heard a reason why this isn't something that ought to be produced. And I then want to hear what this is going to go both ways, so don't misunderstand. I do want to hear from you what you need from the debtor, but to the extent you've got an argument that I haven't yet heard as to why these shouldn't be produced, I also want to not, be too quick to the trigger. So I do want to give you a chance to be heard.
Your Honor, I understand your questions, and I understand the responses that the court has in response to my questions. I think it is, in the end, I think it is important that the valuations are confidential, and I'm not saying that's the reason. I'm not saying that's
right.
I have to
if you need a protective order, I've got no issue with that. You
just took the words out of my mouth. That's where I was going.
Yeah, no issue there. If you need a protective order, if you guys can talk, and I'm sure you all have plenty of templates in your files.
We would agree immediately for the local rule to apply, Your Honor. It's really, we need it, and now that we have capstone, so we don't really have time to negotiate an order. We have a local rule that covers it. We're not sharing it with other parties outside our cone.
Okay, Mr. Lucas, any reason not to proceed on that basis?
Your Honor, I'm familiar with the local rule, and I'm sure that Mr. Denny and I can work out something by a very simple email agreement.
Okay.
I'm not troubled by
that. That's fine. Okay, so that'll solve that. I appreciate everyone's professionalism in that regard. So I think it's now understood that the valuation material will be produced. You're entitled to reasonable discovery too. Look, I'm operating on the assumption that we're talking about a hearing that's going to happen on Friday. It's now Tuesday afternoon. I want to be practical to the extent there are documents that require you to begin interviewing electronic discovery vendors. I know that's not going to be produced for hearing on Friday. To the extent you've got it and it's in a file folder and you can attach it to an email, and it's relevant and significant, you should get it. And so I want to make sure both sides have a fair opportunity to get reasonable discovery in advance of the hearing. With respect to your letter, I think that, Mr. Denny's point that they don't yet have a care and maintenance budget, I'll take that representation, as true for this purpose. But are there particular items that they have, you've been asking them for, and you want me to say, Mr. Denny, you need to produce it?
Yes, to me, Your Honor?
Yes.
Yeah. So, Your Honor, in looking towards trying to resolve this and walking into the court, so to speak, on Friday with a consensual order, it would be extremely helpful if the debtors shared with us the full budget. That is, the budget with all the disbursements and expenditures that were missing in the prior version. I realize that we're working under a tight time frame here, and they're probably drinking out of a fire hose. But for us to go and we're working with them on a form of cash collateral where we need the budget so that we could see where things are going. If it's going to work with all the restructuring expenses and the administration of the estate. Okay,
so Mr. Denny, is the issue there that you don't have it yet, or that you have it and don't think it's sufficiently perfect to share?
Actually, Your Honor, I'm just looking at their letter. The fact is we just received the letter. So it's more a function of, we spent yesterday interviewing financial advisors and bankers, and we hired Capstone last night. So now they're working with the company on the budget to layer in things like professional fees, et cetera. So that's one item. They asked for all these other items also, so the same people are pulling the same information. So a lot of it is a function of timing, because I only have a handful of people to keep pulling information. So, and honestly, that was part of why we were trying to figure out if we're having a contested hearing Friday. We're fine proceeding Friday because we need continued use of cash collateral. We're fine living with the budget if the hearing moves a week and Your Honor has time for that. But in terms of providing them with the information, people are working on the budget. I will get whatever information I can to Mr. Lucas. In terms of requests for the information, again, this is what we received yesterday. So there have not been discussions about this request from them since we received it.
All right, let me try to make my ruling as clear and simple as I can, which may not play to my strengths. Look, nothing in this list strikes me as irrelevant. I'm now referring to the list that Mr. Lucas sent over. Nothing strikes me as irrelevant. Some of it seems, may be things that either don't exist as of this moment, or are particularly voluminous, or obviously I don't know. But here's where I am. And this is going to rely, as all discovery fundamentally does, on the parties behaving in good faith and as professionals. And I have the good fortune here of having terrific counsel on both sides, so I worry about that less in this case than I do in some others. But my expectation is, if we're in a situation where we need to go forward on Friday, and look, to the extent you're able to work out something so that we don't, that's terrific, but we all need to be prepared for the possibility that we do. My ruling is that to the extent there's anything on this list that you're reasonably able to pull and send, you need to do it. And this is what's good for the goose is good for the gander rule. You get the valuation stuff to the extent they've got it and can send it to you, but that rule applies equally to you. And if there's stuff here that you can get that, I understand you're stretched, but providing a fair hearing for the other side is going to have to be a high priority.
Understood. We were not withholding information, Your Honor.
Okay.
And Your Honor, I wasn't suggesting that Mr. Denny was withholding the information on the budget. As I said, I realize that we're all working very hard, but that obviously is a key piece to coming to an agreement. It would be helpful to have it sooner rather than later and not on a Thursday before a Friday hearing.
I understand, but unfortunately my role here is judge, not mediator, so helping you guys come to an agreement isn't really part of my job description. I'm here to resolve disputes. I think information to which you're entitled, if we go to a dispute, might also be helpful to you in working out negotiations, so I'm happy to say he needs to produce it. But again, it's in the spirit of my role is resolving disputes, not taking over the role of mediating.
Well, I appreciate Your Honor's role, both not mediating and calling balls and strikes. There was one other issue I wanted to raise since we're all on and Mr. Lucas is on, because one of the things that you heard at the hearing on Thursday in our letter was, again, trying to nail down what it is will be in dispute in terms of their obligation to identify extent, need, and priority. And they've indicated that they've produced everything they have. You heard at the hearing the testimony that they did not obtain lessor consents to the operating leases. After the hearing, we received the production of the loan documents, pretty much whatever they have. So sitting here today, we have not received anything that looks like a consent from any of the lessors. Just trying to clear through the brush, because when we talk about adequate protection and replacement liens and the like, because that was part of the hearing the other day, I am simply confirming the fact that none were obtained because none have been produced to us. I want to make sure we're all clear on that because that is relevant, again, as we move forward for Friday.
Okay, so Mr. Lucas, if you want, if you have anything you want to say in response to that, I want to give you a chance to be heard. I confess that this issue came at me pretty quickly, and we spent some time thinking about that cluster of issues since then. It seems to me there's a legal question, right? Not just a factual question, but a legal question that no one really presented to me at the first day about what is the consequence if you've got a lien but no consent. And this isn't a burden of proof question because it's about a legal issue, but I would appreciate if I have to resolve that, someone presenting something to me to make me smarter than I am, and the bar there is very low.
Understood, Your Honor.
Do you want a walkthrough now at a high level, or do you want to just deal with that in court?
I think we should deal with it in court to the extent you are able to obviously resolve this, and I never have to think about it. Then more brain cells for something else. But to the extent I have to resolve it, I do want to make sure that I've got the tools to get it right.
Okay, we're happy to do it whenever you're ready for it.
Okay. While we're here, is there anything else that I can do to be helpful to the parties?
We never picked a time on Friday, so when we spoke about are we having a hearing Friday, it was also when.
Right. That's a fair question. And I am reasonably open, so what's agreeable to the parties for Friday?
We're assuming this is in person and not Zoom? That's another question.
That is the convention in this court, and I feel like I should, in the spirit of, predictability and consistency, adhere to it. So there's an exception for first days, but contested matters are otherwise in person.
Yeah, and Your Honor, may I ask Your Honor about the Zoom here? I mean, since we're not necessarily rowing towards a contested hearing, but we're also simultaneously trying to resolve things. We very well might resolve things on Thursday. And, I have to get on an airplane, and that's what I have to bear, and I have to deal with that. And so I'm just trying to address logistics and timing. And
Yeah.
And just to be clear, I appreciate that. And one of the biggest motivators of bothering you this afternoon, and we do appreciate your getting on, is you've got Mr. Walker and Mr. Ronke who moved from the mine in Alabama, flying to Denver, and then trying to get to Trinidad. So it's not an easy trip. And then they'll be coming back. So they really needed to know, are we doing this Friday?
Right.
And the logistics part, John.
Yeah, so look, I appreciate the burden associated with travel.
You're happy to do it.
No, I understand. I know no one's complaining and that everyone will follow the rules. I appreciate that. I do think, as annoying as it is, that as a matter of coherence, I should stick to the rule that the large majority of my colleagues have adopted, which is that contested hearings, other than first days and discovery and scheduling matters, happen in person. I'm happy to set the hearing, if it's better for everyone else, as late as possible to give you as much time to try to work things out before people need to get on airplanes. But I think what we're talking about is a hearing in person Friday afternoon. And in terms of what time, I'm happy to, I'm flexible.
Yeah, I think for our witnesses, they'll probably have to get wheels up, if not tomorrow night, then Thursday morning anyway. So if we're going to be here in town, I have to be here Friday night. I don't know if anyone else wants to be here Friday night. So the sooner we start, the sooner people get out. But we can consult with Mr. Lucas and let Chambers know if that's okay.
That's totally fine. If the parties want to talk and just let us know what time it is, we're happy to be flexible on our end.
Okay.
Okay. Is that Mr. Lucas, that's agreeable from your perspective?
Yes, Your Honor, of course.
Okay.
You know what? I see Mr. Fox open his screen. and he reminds me, because Ms. Copper is here, trying to get real work done. Your Honor will recall that the cash collateral budget that I don't really do a whole lot. They do it all. We had the approval of the cash collateral budget through next Friday, and embedded in that budget was the wages that will be through this Friday. Sorry, I'm losing weeks. We've spoken with Mr. Fox, and we've reached out to Mr. Lucas to see if we could submit under the C&O a supplemental order, making clear that that payroll could be covered. So the order you entered last week was the payroll due last Friday. This could be a stipulated order, making sure we could fund and process that payroll. Mr. Fox, you popping up reminded me of that. I think we're waiting to hear from Mr. Lucas on that, and assuming that's acceptable, I just wanted to let you know that might be coming over.
Oh, okay, well, obviously. Mr. Lucas?
I was going to say, I had a question, and it was answered, but I hadn't had time to respond to it. But I can confirm here it's fine.
Okay. Mr. Fox, you're entitled, no one is required to be put on the spot. Just because Mr. Denny asked the question doesn't mean everyone needs to jump to answer, just so the record is clear. But if you have an answer to that, that's fine. If you want to be heard on some other issue, that's also fine.
Thank you, Your Honor. May it please the Court, Tim Fox, on behalf of the United States Trustee. I just wanted to briefly appear to just ask, with respect to scheduling on Friday, I know that the parties are trying to row in the same direction and get to a consensual resolution. Should that occur, is that then going to flip from in-person hearing to a Zoom hearing since it's not a contested matter?
Yes, if everyone agrees and the only thing you need to do is put an order in front of me to sign, no one needs to get on a plane for that. Indeed, if that's the case, you can submit it under certification and we don't need to get on at all. If people think, if you're in a situation where it would be helpful to make representations for the record, I'm more than happy to have a Zoom hearing. But certainly, if there's an agreed order or agreement in principle that just needs to be set forth on the record, that's not a circumstance in which people need to get on airplanes or even come across town.
Thank you, Your Honor. I just wanted to clarify that, and then in response to Mr. Denny's comments, I had already previously reviewed the form of the supplemental wages order. My office does not have any objection to that form of order as proposed and the process that the debtor outlined with respect to submission of that. So assuming Mr. Lucas and any other interested party that is providing comments does not oppose that, we would not object to entry of that order and submission on certification of counsel or other mechanism to streamline the proceedings with respect to that payroll. Okay,
so in light of that and Mr. Lucas's comments, Mr. Denny, if you submit that to Chambers under certification, we're happy to enter that order.
Thank you, Your Honor.
Any other way in which I can be useful? It seems like the longer I talk, the more peace breaks out. That's the wrong incentive.
Maybe you are a mediator.
No, it sounds like I should stop while I'm ahead. Anything else I can do to be useful?
No, thank you, Your Honor. We'll consult with Mr. Lucas and then get back to Chambers.
Okay. Well, thanks to everyone.
Your Honor.
I'm sorry, go ahead.
Obviously, we will keep Chambers apprised of the progress here, too, and let Chambers know that hopefully Chambers has a free Friday afternoon.
That would be terrific. Again, I'm also happy to do my job if that's where we end up. Thanks to everyone for jumping on relatively short notice. This has been very helpful to me. We'll keep our eyes out for where things stand. And with my thanks, we're adjourned. Thank you.
Thank you, Your Honor.